And the third case of this session is 24-1984 Newrez versus Tesdall. We have Michael Byrne for the appellant and Matthew Laughlin for the appellee. Mr. Byrne, whenever you're ready.
Thank you. Good morning. My name is Michael Byrne. I'm representing the appellant herein, Lene Tesdall, in a case of a mortgage foreclosure and the absence of a notice of right to cure before the filing of the case. This case is one of protection and enforcement of the notice of right to cure under the statute. The appeal of summary judgment of the district court held that Tesdall was not a borrower as a matter of law. And the court cited because she was not a borrower on the promissory note, she was not entitled to the protections of the notice of right to cure.
Legal question that's before us, right? A kind of competing motions for summary judgment, not a fact question, not whether there's material questions of fact.
I think, Your Honor, it's what could be defined as a material finding of fact. And in this case, there was an early ruling of summary judgment against Ms. Tesdall, which was reversed by the trial court, who first heard the summary judgment matter and allowed it to go forward to trial. Then there was a second competing motion based basically on factual law. So I think the statutory interpretation would be, can the court define whether she is a borrower only looking at the statute, because the findings of fact would require that the court acknowledge she is listed as a mortgage borrower on the real estate mortgage itself. The real estate mortgage itself gives her the notice of right to cure by assuming the responsibilities of the deficiency of payments. And that yet is what the bank itself denied her in this case. I believe that the Court on Appeal must hold the bank to the standards that it imposed in implementing the loan, specifically identifying both Lene Tesdall and her fiance, Donald Adjutor, as jointly borrowers under the real estate mortgage. It's undisputed she was not part of the note because she had no obligation. However, even the real estate mortgage states that a borrower who did not sign the promissory note is not obligated to pay the obligations. The only reason that that would be relevant is if the person who signs the real estate mortgage reserves the option given her in the mortgage document itself to address the notice of right to cure and to preserve her interest in equity in the property by making those payments and by assuming voluntarily the obligations that she would not otherwise be enforceable against her. The bank essentially argues that she has no rights. So there is no way that she should have been required to sign a document promising her security interest in the property and yet not have the very options to proceed with a notice of right to cure, which the mortgage itself gives her. The statute is intended to protect homestead interests. That's what Ms. Tesdall had in this property. And the court should liberally construe the statute to amplify the protections intended by the legislature in passing that notice of right to cure.
The district court granted the summary judgment sort of on a lot of different levels, and one of those was that if she does qualify as a borrower, that the notice was sufficient. Because I think the mortgage talks about notice to one borrower as notice to all, why doesn't that just settle the question?
Your Honor, I believe the statute requires that the borrower be given actual notice, and the borrower in this case was two individuals. Rules of statutory construction indicate that the borrower can be used in the singular or plural as circumstances require, and that same language is in the real estate mortgage itself. So the bank had the obligation to send Ms. Tesdall a personal, individual mortgage as she was entitled to protect her interest in the equity. The great harm advanced by the bank's position in this case is that if one were to have a lender who gave a note to a borrower without any collateral, but allowed it to be secured by a residence, and two owners of that home signed the mortgage for the loan as a commercial interest, the foreclosure of the home would not be protected by the statute because neither of the mortgage holders who owned 100% of the property were notified, because only the lender was required to notify the note borrower. In this case, the bank has often proceeded on the basis that a note and a mortgage must be read in conjunction with one another. However, the statute does not use the word note in reference to the borrower. It states a borrower on the mortgage. And this is exactly the language that the bank itself uses in the mortgage, defining her 3 times as a member of the borrower. So under those circumstances, Your Honor, we believe that the court was not entitled to find as a matter of law that she was not entitled to notice, and we would ask the court to reverse the motion granting summary judgment.
About the substantial prejudice for a minute, that level of the decision, did your client need to show more to show that she had the ability to cure?
The notice of right to cure prevented her from kind of timely proving that she had the ability. There are exhibits in the record indicating that she had more than enough money in her accounts in August and September of the year that the cure would have been obligated to pay that mortgage, the delinquency on that mortgage in its entirety. So the first harm is that she was never even advised that there was a delinquency until after the case was filed. That is the true and absolute harm that is in this case. The ability to make the payment is established by her exhibits showing she had cash available, but she also would have had other avenues of making loans or options available had she known that she was required to do so in 30 days. The protections that we seek, Your Honor, are only to enforce the obligations of the state to protect the homestead and to realize that Ms. Tesdall had met those qualifications. The heartbreak in this case is this is her home. It had been her home now for 6 years. She moved her children into this home when it was purchased. And the statute is intended to exactly this type of thing, to provide due process, good notice, and the actual right to cure to anybody whose interest is on the mortgage. So I would ask the court to conclude that anyone who is written on the mortgage itself is absolutely entitled to notice of right to foreclosure, whether they are on the note or not. Thank you, Your Honor.
May it please the court, counsel. My name is Matt Laughlin, and I represent the Appellee-Newrez. This case involves a real estate finance transaction. In a real estate finance transaction, it's typical, as in this case, that there are two important documents that have separate and distinct rights and responsibilities. The first is the promissory note. The promissory note establishes the debt amount, the interest rate, and the repayment terms. The person who signs the promissory note is often referred to as the debtor or the borrower. The person that loans the money is often referred to as the lender or the creditor. In this case, there's no dispute that the only person that signed the promissory note was Don Ergerterra. And so he is the person that is the borrower, he's the person that is the borrower in this case. The other document that is typically, as in this case, a document that's seen in a real estate finance transaction is a mortgage. The mortgage is a document that grants security for the repayment of the loan. It's not itself a debt instrument. The person who signs the mortgage is typically referred to as the mortgagor, and the entity, the bank that is given the mortgage is typically referred to as the mortgagee.
Here, am I right that it did refer to Ms. Tesdall as a borrower, though?
It did, Your Honor. That's a great question, in that the definition of borrower in the mortgage did include Ms. Tesdall. However, if you read further into the mortgage, it clarifies what it meant. Specifically, if you look at paragraph 13 of the mortgage, it adds color by stating that any borrower who co-signs this security instrument but does not execute the note is signing this security instrument only to mortgage, grant, and convey co-signer's interest in the property under this security agreement. Further states that that person that's referred to as a borrower in the mortgage but did not sign the note is not personally obligated to pay the sum secured by the security instrument.
That's a little bit of a different question, right? The obligation to pay versus the right to receive the notice.
Your Honor, I think that those two things go hand in hand, and that's because of the way the legislature set out the statute. Iowa Code 654.2D specifically provides that a creditor who believes in good faith that a borrower on a deed of trust or mortgage on a homestead is in default shall give the borrower a notice of right to cure. Now, there's very important terms that the legislature chose to use in this case. One is borrower. The legislature could have used the term mortgagor. And specifically, if you look at just 654.2D, the legislature refers to creditor 13 different times, borrower 10 different times, and it also refers to a mortgagor 2 different times. So,
Point out, though, that in that language of that statute, it talks about a borrower on a mortgage. Is that just hook us back to the promissory note then, or?
So because this is Chapter 654, which deals with foreclosures of real estate mortgages, so this is specifically talking about instances where there's real estate as collateral, and the collateral is a mortgage. But it does refer to a borrower. And so if you look at, so who's entitled to receive the notice of right to cure? It's a borrower. And what is a borrower? If you look at the appellant's definition in their brief, they define a borrower as he to whom a thing or money is lent. That's the definition appellant is using, and I agree with that definition. So in this case, who was lent money? Mr. Ergerterra was lent money. Was Ms. T?
I guess I'm still just confused why we wouldn't rely on the mortgage's definition of a borrower.
Two reasons, Your Honor. One is that there's the definition of borrower in the note is also just Mr. Ergerterra. And the other is that just because parties call something, give something a name, does not mean that that fits within the statute. We have to look at the statute to determine what it is that's entitled to protection. In this case, the legislature said that it's only the borrowers that is entitled to a notice of right to cure. And just to be clear, I'm not saying that Ms. Tesdall is not entitled to any notice. Far from it. Ms. Tesdall is entitled to an original notice and copy of the petition. In order for the bank to extinguish her interest in the real estate, she needs to be named as a party to the lawsuit so that she has an opportunity to defend, if there's a defense, and ultimately to protect her interest. So how would Ms. Tesdall protect her interest? Just like any other party that has an interest in real estate, the ultimate way for a person that has interest in real estate to protect themselves is to bid at the sheriff's sale. So if they bid at the sheriff's sale, then they can acquire that interest. And Ms. Tesdall is not the only person that it would be similarly situated. Mechanics lien holders have real estate interests. Judgment lien holders have real estate interests. Junior mortgages, parties in possession, and somebody that purchased on contract. If the borrower sells to somebody on contract, they have an interest in the real estate, and they're not entitled to a right to cure letter. This is similar to the case that was relied on by, or at least cited by the district court judge, which there was a situation where the borrower transferred the real estate to a third party, and that party did not receive a right to cure letter. In defense, that party asserted that the bank knew that she had an ownership in interest in the real estate and should have given her a right to cure letter. The court said that she asserted in her resistance she was not the borrower and did not execute any documents in writing assuming the individual liabilities and obligations under the promissory note and mortgage, and did not agree to assume obligations thereunder. Because that party did not have the obligations under the promissory note, she was not a borrower under 654.2D, and that's an unpublished opinion from the Court of Appeals. Another reason that Ms. Tesdall is not entitled to a right to cure is that under the Graham-Leach-Bliley Act, banks are prohibited from giving confidential information to third parties. In this case, Ms. Tesdall is a third party.
Let's say that she had received a notice of right to cure and then wanted to make a payment on the promissory note. Would the bank have any obligation to accept that payment? I mean, practically speaking, how would that work?
Not, and I can tell you in practice, banks will only deal with the borrower. So the borrower needs to be the one that reinstates. The borrower needs to be the one that asks for, so if it's past the right to cure time and there's an opportunity to reinstate, the borrower has to be the one to reinstate. The bank does not have a contractual obligation with a debtor-creditor relationship with somebody that's not their borrower. And there's federal laws that prohibit them from discussing payment information with non-borrowers. Again, the Graham-Leach-Bliley Act prohibits sharing confidential information. On the right to cure letter, which is part of the court file, you'll note that there's a redacted portion in the upper right-hand corner, and that's the loan number. And so while it's redacted in the court file, it's not redacted when sent out to the borrower. And so if the appellant's argument is correct, it would force the bank to send personal confidential information to non-borrowers. That's not what's required by the law, and it's actually prohibited by federal law. I also want to just address real quick, there's an argument that appellants made that because the bank waived deficiency judgment, Mr. Jeter and Ms. Tesdall are equivalently the same. And that's just not the way Chapter 654 is set up. Under 654, the bank first sends a right to cure letter. If the debt amount is not cured within the 30 days, then the bank has the opportunity to file a foreclosure petition. It's at that point that the bank makes a decision as to whether or not they're going to preserve deficiency or waive deficiency. So whether or not the bank makes a decision to waive deficiency after the right to cure letter has expired is irrelevant to these proceedings.
Could you address the argument that was made by your colleague that the purpose of 654 is really to preserve homestead rights, so their interpretation of the statute does more toward advancing that purpose?
I don't find that within Chapter 654 that that's the explicit purpose. In fact, Chapter 654 does set forth mechanisms to waive the homestead right by specifically, there are specific homestead waivers that are required. And I would point out that in this case, the mortgage did contain that homestead waiver. I think that if the legislature had intended to allow the, my time's almost up, I'll finish this thought real quick. If the legislature had intended for mortgagors to be protected, they would have said so. They would have used the term mortgagor. But because Newrez is not a creditor to Ms. Tesdall, because Ms. Tesdall is not a borrower to Newrez, and because Ms. Tesdall was not in default on the loan to Newrez, she was not entitled to a right to cure letter. Therefore, we ask that the court affirm the district court's ruling. Thank you very much.
Thank you, Ron. It is interesting to me that in this case, the bank seems to stress that because Ms. Tesdall was not on the note, she was not entitled to the right to cure. However, she didn't sign the note, so she has no necessary connection to the note. It is in the real estate mortgage itself that she is advised she, as a mortgage borrower, has the right but not the obligation to go ahead and assume responsibility for delinquent payments under a right to cure which would be provided to her as a mortgage borrower, and that she has a right to protect her equity if she elects to do so. It's not an obligation. This case would have been easily reviewed and decided if the bank had put the language in the real estate mortgage, which it claims there is. Often in farm real estate mortgages where the spouse is not a farmer, has an independent income and occupation, the language will say that even though she signs over her interest in the security, she has no protection and no obligation other than to surrender her real estate. It does not promise her a right to cure. In this case, the bank must be held to the language that it placed in the real estate mortgage, and that language must control the application of the statute. She is clearly defined as a mortgagor who is a borrower. Her name is on the mortgage. The case cited by Mr. Laughlin and used by the trial court assumes that there was a third party who assumed the mortgage, and that case turned on the issue that she had never signed a mortgage. The bank may have known who she was, may have been able to find her as a interested party, but she did not fit the language of the statute. She was not a borrower on the mortgage itself. The limit that the law puts on the bank is not huge. It is simply to look at the mortgage to see who was identified and who was promised the right to cure, and then to apply that law.
Language in that statutory provision that requires the creditor to deliver notice to the consumer. Does it make any difference that they switch to the word consumer kind of midway through that provision? Do we think that's just synonymous with borrower?
I think consumer would be read inclusively and include the mortgage borrower, because she is a consumer in the fact that she benefited from the loan. She had a purchase interest in the loan given to Mr. Adjutor, and the bank was well aware, because they were the purchasing financiers, that the deed was being taken immediately as a joint interest with full right of survivorship. So the bank had no lack of understanding as to what was happening, and they deliberately chose to evade giving Ms. Tesdall any right to cure actually in the documents.
Can you respond to your colleague's argument that providing this notice to cure to someone who is not on the loan would violate federal law?
It's interesting to me, Your Honor, that the bank chooses to say that a lender is only the note holder when the bank's own documents define both Ms. Tesdall and Mr. Adjutor as a borrower, and they connect both documents together, yet when it's not in their interest, they say they had no way that they could disclose that Mr. Tesdall was delinquent in his obligations under the loan, even though that's what's promised in the real estate mortgage itself. So I believe that in this context, federal law would not prohibit disclosure of that condition, which is part of the loan documents. They are related parties. This is not some third-party stranger who's simply curious as to what might be included in those documents.
Thank you. Thank you both for your helpful briefing and responsive arguments today. We really appreciate that. We will consider Newrez versus Tesdall submitted, and we'll have a written decision as soon as possible. And that concludes our 9 o'clock session.